Welcome to the Reynolds School First Amendment Forum. My name is Patrick Feil. I'm an associate professor of media law at the Reynolds School, and I get to welcome you and introduce our guests and set the stage for our discussion. First, I want to extend a heartfelt thanks to Warren and Janet LaRude right here. Warren is professor emeritus at the Reynolds School, a longtime media law professor, and he and Janet are committed to ensuring the First Amendment remains a core value at the Reynolds School and at the University of Nevada. Their generous support helps make this event possible. It's also worth noting, since we're going to be talking about Nevada's shield law a little bit tonight, that Warren is a primary reason that we have that law. In 1968, as a managing editor of the Reno Gazette-Journal, facing the threat of being forced to reveal confidential sources, he got the ball rolling on what would become Nevada's version of the law intended to protect those sources and the free flow of information to the public. But thanks to Warren and Janet. I'd also like to thank KUNR for their promotional support of the event, and of course I'd like to thank the wonderful staff at the Reynolds School and here at the Knowledge Center for helping everything run so smoothly. Earlier today, the Reynolds School honored Las Vegas Review-Journal investigative reporter Jeff German, who was killed in September of 2022, allegedly by a government official he had reported on. The award was the Frank McCullough Award for Courage in Journalism, and Jeff surely demonstrated that in spades. But good journalism, the kind that Jeff did, that sheds light in dark places and holds the powerful accountable, takes more than just courage. It depends on legal support, the kind that puts conviction behind our democratic commitment to a free press in the First Amendment. And for better or worse, that means we need lawyers. Pause for laughter. So we've invited two eminent attorneys engaged in the effort to ensure that those protections remain strong and meaningful, to learn about a particular issue that arose out of Jeff's murder and to consider how that case might help us reflect on various legal challenges facing journalism today. Ashley Kissinger has represented media and entertainment clients in First Amendment and related matters for 25 years. Her work has helped establish key rulings protecting the free expression rights of everyone from media corporations to individual critics of businesses and government officials. She's also worked on international issues of press freedom and independence, particularly in the Arabian Peninsula. She is lead outside counsel for the Las Vegas Review-Journal in its fight to keep law enforcement from searching Jeff German's phone and computers. Ben Lipman is chief legal officer of the Las Vegas Review-Journal. Prior to joining the Review-Journal in 2019, Ben was in private practice in St. Louis for over 27 years, practicing primarily in the areas of media law and commercial litigation. A federal appellate judge, fun fact, once remarked that Ben wields the First Amendment with reckless abandon. Ben has always taken this as a compliment. So Ashley and Ben will start us off by talking about what brought the case that went before the Nevada Supreme Court and put its key question ruling in a broader context, followed by some of the other legal issues and questions and challenges that they see facing the press today. Then I'll have a couple of questions to extend that conversation, and as always, we'll dedicate the last 30 minutes of this forum to your questions. So please help me welcome Ashley Kissinger and Ben Lipman.
I think we would like to talk first just about what the SHIELD statute is to set the groundwork, and then we can talk a little about what happened to Jeff and what led to the fight that we, mostly Ashley, had to fight. I feel odd talking about the SHIELD law and explaining it with the man who wrote it sitting right here, but I'm going to try and do it justice for you. The idea of protection for the media, of course, comes from the First Amendment, as so many protections for the media do. The shield, the idea of a reporter's shield originates with the First Amendment, and the U.S. Supreme Court has never made a definitive statement on just what the parameters of a reporter's shield would be. They have made some statement on it, and the other federal courts have for the most part agreed that there is a reporter's privilege, but how far it goes, how broad it is, how deep, narrow it is of some debate in our country among the courts and among legal scholars. And so each state has had to decide on its own whether to protect reporters and protect reporting, and if so, to what extent. And through the great hard work of those who are instrumental in making the law, we here in Nevada are fortunate to have the most powerful, the strongest protection for news gathering, for Reporter Shield anywhere in the country. And that statute says that no reporter or other employee, and it lists a number of, who work for newspapers and news organizations, we'll leave those details out, can ever be compelled to disclose their news gathering, their confidential sources, of course, but not just their confidential sources. Confidential sources, non-confidential sources, the information they have received or gathered in preparation for disseminating that to the public. It can't be compelled, they can't be compelled to disclose that under any circumstances. We being the media, we can disclose it if we want, and in fact, that's what we do literally every day, 60, 70 times a day. We gather information and we decide what to release to the public. But in order to do that and to do it right, we absolutely have to be able to protect that which needs to remain a secret. And so again, each state then has developed their own laws, and here in Nevada, we have ours. And in this case, the fight ensued after Jeff Gehrman, one of our reporters, was murdered. I assume you all know the story, but for those who might not, I'll just briefly talk about it. Jeff was our longest serving investigative reporter, including his time with the Las Vegas Sun and his time with our newspaper at the Review-Journal. He had been 40 years in the business, was the most sourced investigative reporter in the state, maybe in the state's history. And he had done some reporting on a low-level local elected official. For those, again, who know Jeff's history, pegging this one as the one that would, this story is the one that would take his life is rather a surprise. I mean, Jeff had reported on everything from the mafia to the boardrooms of Nevada. He had CEOs that would certainly probably love, not literally, I'm happy to say, but love to do him in. The mafia, Tony Spilotro famously once punched him in the face over the reporting. And here he was reporting on this low-level public official, reporting that didn't disclose criminal behavior, just really reported that he was a lousy boss, he ran a lousy office, the kind of information that voters would want to know to decide whether to return him to that office, and they chose not to. And of course, I mean, he's only been charged with the offense, but if he turns out to do it, I think we would look back and think this was not one we would have guessed would be the person to do it. But we got word over Labor Day weekend that Jeff had died, and we quickly found out that he hadn't just died, he had been murdered. And our newsroom, after a very short time of, I think, shock and depression, you could just feel the switch in the newsroom, and a whole lot of people saying, this is what we do, we're going to solve this crime. It's what Jeff would do, it's our jobs. And they quickly went to it, and it didn't take long to focus on the guy who's been arrested and charged with it, and the police focused on the same person, and a few days later he got arrested. Taking a step back, though, to when Jeff got killed and the police showed up, they took the cell phone from his body And they soon after went into his house and took several computers and a hard drive, 6 devices altogether. And of course, like everyone, Jeff's devices were what he did his job on. So those devices contain a whole lot of our news gathering materials, our sources, our confidential sources, and we soon thereafter found out that the police had them. They assured us that they had not looked at them. They asked us, recognizing the SHIELD law, if they could look at them, and we said no. You can give them back to us, and we'll take a look, and we'll withhold our privileged information. We're happy to give you everything else. We want Jeff's killer caught, tried, and convicted as much as anybody. But they were not willing to do that. They weren't willing to agree that anybody but the police and prosecutors could look at the materials. And so we then had a fight on our hands about whether they could look at it, which we said they couldn't. They fought whether we were allowed to stand up and argue that. And off we went to the races to court, which is when I called Ashley.
And I've been very busy ever since. So the main legal issue in the case, and this is a very unusual circumstance, because usually when it happens that people want to find out what the press knows, and it can happen in connection with a civil case, it can happen in connection with a criminal case like this, and typically the way it happens is a subpoena is issued to the reporter, and then the reporter and the reporter's employer hires somebody like me to help them quash the subpoena, move to quash the subpoena, asserting the SHIELD law rights of the reporter, and that's how it goes. Here, the police had just seized these devices via a search warrant, and so they were just asking after the fact, we have this stuff, can we look at it? Kind of acknowledging the SHIELD law, but not well, at one point they did expressly acknowledge the SHIELD law. But then once they said no, suddenly they said, well, you don't have the right to assert the SHIELD law, because the SHIELD law isn't written in terms of the news entity being able to assert those rights. So statutes are written with words have meaning, and the statute says no reporter, former reporter, or editorial employee of a news entity may be compelled to disclose. It doesn't say no news organization may be compelled to disclose. And so that was one of the biggest issues in the case, was with, does the Las Vegas Review-Journal have the legal standing to assert these rights in the wake of its reporter's murder? And that was one of the biggest issues we had to fight. Another issue was, let's say the newspaper do have the legal right to assert this privilege. How do you go about asserting it? And in this particular case, in modern times, reporters use devices for personal stuff and work stuff. So the devices had Jeff Gehrman's personal photos and contacts and voicemails, and his computer presumably also has personal stuff on it too. But it also contains his work product. And so if we did have the legal right to assert the News Shield statute, well, how do you effectuate that right while also maintaining privacy over Jeff Gehrman's, personal stuff? So we had offered up to the other side being the police department and the state of Nevada, the prosecutors. Listen, we understand that, we get it, but it is our work product that's on there too, so we'll have special masters look at it. Special masters are used in cases, sometimes they're just independent, third-party, neutral arbiters, so not the judge, not any of the parties to the case, but third-party people. And we offered up specific people who are experts in criminal law, One is a federal magistrate judge who used to be a criminal defense lawyer. The other used to be the DA of Clark County, Nevada, who is now the general counsel of the police union. And so we said, look, they know what they're doing. They know what to look for, because that was always a big objection. You guys don't know what to look for, right? This is our case. You don't know what our theories of the case are. So how are you going to be able to look at it, you, the newspaper, and determine what's useful to us or not? And we need to be able to look at it. They have always also asserted that it was Mr. Tellis, so Robert Tellis is the guy who is on trial for Mr. Gehrman's murder. And the state always took the position that, hey, we have an obligation as the state to give over any exculpatory evidence that is in our possession. And that is true, right? That is a constitutional obligation of the state. It's also a statutory obligation. But we said, well, you don't know that there's any, and exculpatory information is information that would tend to prove the innocence of the person accused, okay? Our position was, how do you know there's any exculpatory information in there? It's not in your possession yet. You don't have a current legal obligation to do anything. And then at a certain point in our case, Robert Tellis decided, at the beginning, he was siding with them. Hey, we want to look at this stuff, and we want to look at it right now. Then he decided to represent himself. He happens to be a lawyer by training. He decided, I can do a better job by myself. And then he is suspicious of the police and the prosecutors. So he actually decided that our suggestion was the safer one for him and said, we agree with them. We agree with the newspaper. We should have special masters look at this stuff and determine whether there's evidence on it that is relevant to the criminal case, and if the newspaper is asserting the shield law privilege, it's called a legal privilege, asserting their rights to keep certain information that is relevant to the criminal case protected because it's either confidential source information or other unpublished information that is sensitive. Maybe it's, stuff that's going, in process to be published in the future. We will let the special masters look at it and sort all of this out. So I don't know how far we want to go. We could talk forever, but those were the main legal issues that we had to deal with. Does the newspaper have standing? If they do, well, who's going to review these devices? And then one last big issue I'll say is there's no issue in our minds that the News Shield statute, and probably in Mr. LaRue's mind too, it is an absolute privilege. So there's two kinds of legal privileges, an absolute one and a qualified one. An absolute one is, this is absolute. Under no circumstances can a reporter be compelled to reveal this stuff, ever, under any circumstance. That's called an absolute privilege. A qualified privilege is, well, there can be circumstances under which that privilege can be overcome by more important circumstances. So the state has been arguing in this case that, hey, a criminal defendant's constitutional rights to a fair trial trump the newspaper's shield law rights. We have always said, no, they don't. The statute doesn't contain any exception there. And the Supreme Court, in its decision in our case, and prior to this case, they had used loose language in some other shield law cases to suggest that perhaps a criminal defendant's rights could overcome the press's rights. And that kind of loose language is still there on the books, even after this case. So, and the case goes forward, right? What happened is that we got the Nevada Supreme Court to agree that the newspaper does have standing to assert the privilege. Yes, it needs to be these two special masters that look at the stuff. And then after that, if there is any material that is privileged the newspaper does not want to reveal, then and if there's any dispute, if the parties still want to get at that information, then you have to go to a second legal proceeding before a judge to figure out well, is it an absolute privilege, or can it be overcome by the criminal defendant in this particular case? So that's the ultimate, kind of, that gives you the lay of the land on the main legal issues in the case.
Can we back out a little bit
Yeah.
just to sort of to broader context before kind of maybe moving forward? One thing I was hoping we could get into is the kind of, if there are things that this outcome and that this case can kind of help us reflect on maybe more broadly, but before we get there, if we could kind of just nail down a little bit more about sort of the stakes of a reporter's privilege. Why have one? Why have states decided that this is something they want to do, even in the absence of a kind of clear constitutional First Amendment obligation that the U.S. Supreme Court has given? And what are maybe the arguments where this is not something that should be, either it shouldn't exist or it shouldn't be strong, right? Maybe a qualified privilege is better than an absolute one. So maybe just the kind of bigger picture in why we might have one of these laws and maybe the strengths and weaknesses of Nevada.
Sure. I mean, I think, for us, this case demonstrates the broader issues and of what's at stake. I mean, we look at this and we know that on this phone are the names of confidential sources, other sources, information that we as a newspaper, through Jeff, were gathering for future stories, looking at the sources themselves, because I think that's really the easiest place to see how high the stakes will be. There are sources on those devices in the police department, in the prosecutor's office, in the courthouse, that work for the judges, maybe some of the judges themselves, people from corporate boardrooms, people from all walks of life in Las Vegas, in Nevada, and elsewhere. And just looking at the police officers, if two police officers and two prosecutors can look at what's on Jeff's phone and see what other police officers are confidential sources for the Review Journal, figure out, maybe be able to tell from those names which one of them had what to say in past stories that were very upsetting to their fellow police officers. I mean, those people could be ostracized from the other police officers. They could be passed over for promotion once their fellow officers know about it. They could be demoted. They could be fired. And honestly, people have been killed for this sort of thing. For us, we take protecting those people, those sources of ours, and what we view as really, I mean, honestly, protecting their lives or the potential that they could lose their lives very seriously. And we believe the consequences could be devastating to those sources, but to news gathering as well. It could interfere with ongoing stories that we're looking at, that information for which might be on the phone. And of course, the impact over the long haul, if sources out there know that there are ways that the information they provide and that their names can become public. I mean, I can't think of a worse legacy for the tragedy of Jeff's life, that the privilege he relied on more than anyone else would be eviscerated by his death. And the idea that if we had not succeeded in this and the police and prosecutors had won in their argument, the impact would have been that if you wanted to get to a journalist's sources, all you had to do was kill him. And you then, after getting arrested for his death, could then go ahead and see what was in there. Or maybe get away with it and have people you know who ended up being the ones to look at it. But for us, I mean, those stakes in human lives, again, even putting aside whether we'd be killed, the impact it could have on the lives of sources, but then also for news gathering going forward, the impact it would have that would make it harder for us to get sources to provide us information. And because the Nevada Shield statute is the strongest in the country. Now, a ruling by the Nevada Supreme Court on a Nevada law isn't binding on any other state looking at their own law, but judges from state to state do look at their sister states to see how they handle cases when they have difficult decisions to make. And if the strongest shield statute in the country were to be undermined, it could have consequences across the country when other states feel that, you know, maybe we should start inventing exceptions to our shield laws. So for us, I mean, for us as an organization, those were the stakes that we felt we were facing.
And then, you know, I can add, you know, when we file these motions to quash subpoenas, the usual way that I'm making these arguments, we talk about the burden on the press of having to respond to a subpoena. I mean, especially now in modern times, right? Newsrooms are being drained of their resources. They are supposed to be going out, you know, reporting the news. If you get a subpoena all the time, if it's easy to get information out of the press, whose job it is to go find the information of interest, then subpoenas would just happen all the time, right? And then you have reporters going into court, accompanied by a lawyer, making objections here and there to this and that and the other question. It's an expensive burden on the press. And so it's really important to have the shield laws at all and have them be as strong as possible. And you know, just to give you a sense of what it's like in other states, I come from Colorado. We have a qualified privilege there. So some legislatures have made the calculus that, hey, we don't need to make it absolute. Let's give some specific situations where it can be overcome. And for example, in Colorado, if a person is on trial for a class 1, 2, or 3 felony, the shield law doesn't apply at all, right? You can get at the information no matter what, which would have happened here. We wouldn't have had a shield law to assert. If it's another kind of crime, you can still overcome the shield law protection if you can show that you can't get the information by other means. There's also an exception for situations where the reporter witnessed criminal activity. Now that's really not a great exception, because a lot of great reporting comes from reporters reporting on criminal activity. and you know, the very establishment of shield laws comes from some situations where reporters were going out and speaking to offenders, drug offenders, right? People engaging at that time, just even possessing marijuana was a crime. Well, to get at the real story, you had to go interview the people smoking the marijuana. Well, what do you think about these laws? And that, you know, that happens in all kinds of contexts. So that's, to me, that's a terrible exception, because, well, you're going to just undermine and not have a lot of great stories, because the press might not be able to get access to the story, right? The actual meat of the story, because there's going to be an exception to the shield law there, and they're not going to be able to protect that confidential source who is engaging in that criminal activity that you're trying to report on. So there are a lot of different ways that people look at these things, and I just am really grateful to have been involved in working on the Nevada shield statute. California has a very strong absolute shield law privilege too, that I've litigated over. And you know, it's really interesting that the shield statutes around the country, which I had never really looked at a lot of them until this case, they're really all over the place. I mean, they are written in all kinds of different language and words. But we were talking earlier about the delicate process of legislation. You know, if you want to go fix a law, you better be careful what you wish for, right? Even though you could tinker with our shield statute and make it even stronger, maybe write in to the shield statute that even a criminal defendant's constitutional rights do not overcome this law. Well, you know, if you actually wanted to go try to get that in there, you might actually undo the law, because you get into the, legislative horse trading, and next thing you know, maybe you don't have a shield statute at all. So it's interesting. It's an interesting area of the law for sure.
I want to kind of tee up the recent movement on the federal level within the last couple of months on a potential federal shield law. And to get there, just to kind of, again, maybe back on some of this broader context, bigger picture stuff, it should be fairly clear that, this is maybe a rare circumstance, maybe not, in the law where this really sets journalists apart. If you can define journalists however you define it in the law, then they have this privilege, and it's a privilege that, the type of privilege that extends in other circumstances. Married spouses, an attorney-client, and the sort of priest-penitent or religious leader and those kinds of circumstances. But to give, I guess what I'm driving at is to give the press a sort of this strong and powerful of a special privilege. If you're not a member of that class, if you're somebody who even maybe has some doubts or mistrust around the news media, why would you what would be the argument that they should support this kind of a thing existing? Again, certainly at the state level, but even maybe at the federal level.
Good.
Well, I think the fact that the freedom of the press is enshrined in the First Amendment to our Constitution demonstrates the importance that we as a nation put on a free press, and I think we do it because it is vital to our democracy. I personally think it's vital to our democracy, whether my opinion, regardless, clearly our nation thinks it's important. And I don't think it is a stretch to say that there is good reason to treat the press special, which is why we did enshrine it in the First Amendment. We're the only industry with our own constitutional amendment. And I think the argument is for the same reasons that we give this industry constitutional protections in areas where we find or we're concerned that perhaps the Constitution has missed, that there are some bare patches that through the hundreds of years of our union we have discovered that there are some places where the First Amendment maybe doesn't provide the kind of protection we think is necessary for the media, that we state to state fill that in and say, you know what, this is an area where the First Amendment isn't providing the protection, but the need for the protection is the same. That is the survival of journalism and its importance to our democracy, and therefore we're going to fill that in. I also, point out that the biggest area where the counter argument, which is that, well, but our police functions are important too, and we need our police to be able to go after people. It's not like if the press gets a hold of the information, then the police can't have it. The police still have as much access as they would have had if the press didn't exist and the press didn't get it. And in fact, we're helping the press function because there are people who will come and speak to the press. And there are stories that will get out there that will let the authorities know something is going on. And then they can go and do their job. Nothing is stopping the police from gathering information on what we've disclosed, but it wouldn't have been disclosed in the first place. And I keep singling out the police because that's often what you hear and counter, but that works for our government entirely. Think of how much has been improved in our government system that wouldn't have been if the press hadn't reported it, and frankly, they wouldn't have had we wouldn't have had the opportunity to report it if people didn't feel comfortable coming forward to us. But again, no one's prohibited from going to the police after talking to the press or before talking to the press. And frankly, I wouldn't be surprised if many of our confidential sources come to us after they found that official channels either got them nowhere or weren't available to them at all because of concern of retribution.
And if I can jump in,
Yeah.
and speaking about the federal, so there's a federal statute, a federal shield law that we need to be enacted. And it has passed the House and was just referred to the Senate Judiciary Committee about a month ago, and is closer to being enacted than ever before. And it will fill in a lot of the gaps, right? You will have a federal statute, and then the state statutes will still exist, and they can provide even more protection than the federal statute. But the way that the journalist is defined in this Federal Press Act, I think it's called, is a functional definition. It's not a definition of, oh, if you're a member of a newspaper or a television station or radio station, as we historically kind of conceive of the press. It is more of, if you are regularly engaged in the practice of acquiring, gathering information and disseminating it to the public, you get the protection. And I think that has appeal to people who are maybe mistrustful of the traditional mainstream media, the press, as it historically was known, because it gives the protection to the right-wing blogger, the left-wing blogger, and anybody who's regularly engaged in the practice of journalism. And that's just important, even if it wasn't defined in that broad way, it applies to if you have some, I guess, element of, even if you're defining it in the traditional way, you have partisan publications, you have a more, on the left and the right. And then you have mainstream news organizations that are endeavoring to not be partisan. And it applies equally to all of them, right? And all of those have a role to play, I think, in our marketplace of ideas and in our, understanding our institutions and our people. And so I would hope that the notion that it protects the provision of information to all of us should be appealing to all of us.
Right. I think the way that the Nevada State Supreme Court has referred to it a couple of times in the case law is the free flow of information. It's the free flow of information that's being protected here, and I think that's part of the federal effort as well as kind of references to that concept.
Yes.
The other thing that stood out to me in that federal, that proposed law is that it deals with something that has come up in recent years, I think, around sort of ways that authorities have kind of gotten around going directly to a reporter and saying, I want the names of your sources, or I want you to hand over this unreported information, and instead going to third parties like their internet service provider or their cell phone company and sort of finding out who they've been in contact with, or even sort of GPS types of data where it's sort of like where they've been going to figure out who they've been meeting with. And so in those cases, the authorities don't even sort of need the reporter's cooperation. They don't need to kind of, they can get that from another party. And I think if that's considered a loophole, that's something that this bill tries to close. And the reason I raise that is because I know that we kind of, is often the case with these things, we kind of had a running conversation via email before we sat down here tonight, and I was wondering if we could kind of move towards some of the other types of threats that you see, either kind of within the context of the Gehrman case, or sort of other kind of types of cases that you're seeing these days, or issues that you see arising around kind of threats to reporters, threats to the press that we can kind of talk about as kind of the broader context for some of these things.
Sure. I mean, I'll talk about one that I've alluded to already, which is the fact that this was done by search warrant and not by a subpoena. Those are two different forms of legal process. And, I think many of you in the room may be aware of, in the past year and a half, maybe, there have been several instances where local law enforcement authorities have just gone in and raided newsrooms, right? It happened in Marion, Ohio. It recently happened in Alabama.
Kansas. Marion, Kansas.
Marion, Kansas, I'm sorry. It recently happened again in Alabama. It happened, well, not the same quite thing, but law enforcement just expressing the desire to kill journalists in Oklahoma recently. Those things are of serious concern, I think. And there is a statute, there's a federal statute on the books called the Privacy Protection Act that we have raised in our case that is very clear. It says you cannot take the information, materials, including cameras and laptops and physical papers or anything from a journalist, period. I mean, with some few exceptions that don't apply in our case. So we have always said just your initial seizure of those devices violated a federal law. And I don't think a lot of people know about that statute, and hopefully bringing awareness to that statute to the Las Vegas law enforcement authorities will prevent some of those things from happening in the future. But that's of a concern to me, is that it seems like maybe some of the authoritarianism that is creeping into our culture, broadly writ, maybe is filtering into the local law enforcement agencies who feel like they can just go, I don't like what the press is writing, I'm just going to go in there and see what it is or grab what it is.
Right. I think in both the Alabama and the Kansas cases, it was, there was specifically sort of reporting on law enforcement or on local government authorities that sort of precipitated the raid, where it was clearly, they sort of had a basis for, well, we think you're engaged in something illegal, or some form of kind of low-level espionage, which would arguably be what reporting would be, that justifies coming in and again, sort of storming the newsroom and confiscating material and doing things like this, which, as you say, is like if there's a competent lawyer that would review that search warrant, they would say, well, wait a minute, this is likely to violate the federal law against this.
Yeah, if we're talking about just the threats to the news media, I think in part, one of the biggest problems is just the willingness of everybody to express and take out their anger on the news media. The sort of shift in view of the media generally in our country. We've seen in other countries the sort of violence that there is routinely against the press, of which now here, tragically, Jeff is a victim. We certainly hope that it's an anomaly. Up till now, it has been, but there is certainly more negative reaction to the media going on in our country, whether it's using the courts in efforts against the media, or the sort of online trolling that goes on, or things like there's a reporter for New Hampshire Public Radio, Lauren Julian, she did investigative reporting a year or two ago on a very prominent local person who owned rehab centers for people going through drug rehabilitation. And there were allegations that he was preying on the women coming through there. And she did great investigative reporting on it. And shortly after she was doing podcasts actually, shortly after the initial reporting came out, her parents' house got vandalized. And they didn't think anything of it at the time, but bricks were thrown through their window. The C word was spray painted across their garage. And her parents had mentioned this to her, and a day or so later, her editor said, "Oh, hey, my house got vandalized and a brick was thrown through my window." And she said, "Wait a minute, this is a bit of a coincidence." And then her former home, she had recently moved, got vandalized, brick through the window, C-word spray painted. And after some time, they found her new address and did the same thing to her. Eventually, one of the best friends of the subject of the article was arrested, along with a couple of people that he had worked with to do it, and they've recently been convicted. In the end, it was vandalism, but I mean, she was certainly fearful for her safety, her family's safety. She had to deal with her family saying, "Do you really want to do this? You have a small child," and that kind of pressure against the news media now, and it's found its way for us. For us, Glenn and I, in the most tragic sense, for us meaning the media bar, into the courts with the sort of I feel silly using threats now in this context against press protections. We've already seen a couple of Supreme Court justices question New York Times against Sullivan and the important protections that provides us. And I worry that it's all a shift in the tide. I worry that because that's harder to stop than individual instances. And if that is a shift, we have a whole lot more that we're going to be facing and fighting over the years to come.
Sure. Can we talk a little bit about libel law and some of the maybe prominent cases and sort of the sense that you have one way or the other about whether this is, kind of a shift or, and maybe we can touch on anti-SLAPP, which I know is another effort at the federal level and something that a lot of states kind of almost in parallel to, in some ways, to a SHIELD law might be kind of another kind of, there's the state level and then there's the federal level.
Right. So Ben alluded to libel or defamation law there when he talked about New York Times versus Sullivan, which is the U.S. Supreme Court case that held that if a public official, which is now broadened to public figure of any sort, is suing somebody for defaming them, that public official has to prove that the person who said the thing did it with actual malice. And it's kind of a weird term. It's, we think of malice as evilness, and that's not really what it means. It means knowing that what they said was false, or being reckless about whether what they were saying was true or false, okay? And that's a pretty high burden to prove in the law. And without that standard there, the other standard that is generally in place, or that could be in place, is mere negligence. You've probably all heard that term. Was the speaker negligent when they said that? Were they not careful enough? Were they sloppy? It's a lot easier to prove that somebody's maybe wasn't careful enough, was a little bit sloppy, than it is to prove, oh, they recklessly disregarded whether what they said was true or false. So that legal protection is extremely important to the press because it dissuades a lot of people from suing for libel because, hey, you're going to have to prove this pretty high standard in order to win. And the reason why we have that standard is to give breathing room to the press to actually go out and vigorously report on wrongdoing. Without that kind of protection, you could get sued all the time, right? Because all you have to prove is negligence. So a couple of Supreme Court justices have written in ways that they didn't need to write, in circumstances where they didn't need to say anything. These are in the context of not an actual court case that the Supreme Court was deciding, but a denial of a petition for certiorari, which is requesting the Supreme Court to take the case. The court says, we're not taking that case, but these one or two justices will just write an opinion kind of talking about this issue, and it's Justice Gorsuch and Justice Thomas have written several times now, basically wanting to undo this actual malice standard for the press. And since they have done it, a lot of lower court judges are now working that into their opinions. And so that kind of thing gradually does undermine the standard and makes people nervous that, that standard may go away. And it's a really important protection for the press in libel cases. You mentioned also anti-SLAPP statutes. It's kind of a funny name. It's an acronym. SLAPP is Strategic Lawsuit Against Public Participation. And so there are statutes that basically protect speakers of all kinds, not just the press, but any speaker. But they're, the press industry is engaged in speaking all the time, so it's very important for the press. These statutes that give them a way to win a case that does not have merit earlier on in the case, so they don't have to spend as much money fighting the case. And a lot of states, well, maybe, I think 32 states have anti-SLAPP statutes, these statutes that give the press and other speakers this important legal protection. But there's no federal statute, and the other states don't have any such statute. And it's been very hard to get the federal, the Congress to pass an anti-SLAPP statute. And I think the last time it was introduced was in 2022, and I don't know that anybody's planning on introducing it anytime soon. But that's a important protection that we hopefully would come at the federal level as well. I don't know if you have any other thoughts on the libel subject.
No. I think that was a.
And in terms of just what we're seeing, so I don't know if you remember back when Donald Trump became president, it was maybe in the around 2016, 2017, he famously said, hey, we're going to open up the libel laws and we're going to sue people and win lots of money. I think that was literally what he said. And there was concern that there would be a lot of libel lawsuits against the press after that. And we were just discussing, have there been a lot more libel suits? It's kind of hard to know. I don't really know, but I have the sense that there have been more. And there have been more from people, maybe, right-wing people who feel wronged by the press and sue what they perceive as the left-wing media, right? And there have been several libel suits, for example, by January 6th participants against the press who reported on what they did on January 6th. But I don't really know if the volume has increased. I don't have a sense of that. But one other thing that has been objectively looked at that is a similar sort of threat to press freedom is the number of courts issuing prior restraint court orders. And a prior restraint is it can come in lots of different forms, but when it comes in the form of a court order, it is the court saying to the press, you cannot publish this, right, before the thing is published. And that's really anathema to, in American jurisprudence. Like, you can't do that. The government can't do that. There are ways you could be punished after you speak. You can be sued for libel, for example, but the government can't come in and prohibit you from speaking at the front end. And that was a formative part of our First Amendment's enactment. This year, in the past year, there have been 11 courts in the United States who have issued these prior restraint orders. They're just unconstitutional, like flat out, no-brainer unconstitutional court orders. And I just had to defend one in Colorado. And Press Freedom Tracker, it's a feature of the Freedom of the Press Foundation. They recorded 11 of these in the past year, which is more than they've ever seen since they've been tracking them, which has been since 2017. So it's not a huge sample size, but that is concerning. Because judges, they do go to judge school. They literally, when you become a judge, you go to this.
There's one here on campus.
Is there?
Yeah. Right. National Judicial Court.
You're expected to know certain things that judges in that context of, litigating cases in the public need to know. And that's one of the things you learn in judge school. So it's sort of shocking to me that it happens as much as it does.
That's really interesting. Speaking a little bit on, and maybe as a last question from me before we start asking for your questions. So So get them ready. Speaking of so anti-SLAPP, for example, a law that certainly benefits the press but isn't exclusively held by or used by the press. Public records laws are another area where this is a law that extends to anybody can use in most cases use a state's public records law or the Federal Freedom of Information Act to request information from the government, find out literally as the U.S. Supreme Court has put it what the government is up to. And I know, Ben, you wanted to talk a little bit about, because as kind of high profile as the Shield Law case was, I know the litigation that and kind of cases that you're most often involved with at the Review Journal have to do with public records cases. Can you talk a little bit about sort of the status maybe of the Nevada Public Records Act and kind of some of the types of cases and issues that you're encountering?
Yeah, the litigation we do have most is Public Records Act litigation, and we have so much of it for the simple reason that the governmental entities in Nevada, up and down the state, flagrantly flout the Public Records Act. Like our Shield statute, our Public Records Act is a very good one. It's not the best in the country like our Shield statute is, but it's a darn good Public Records Act. And I can actually remember still back when I was interviewing for this job, and I met with Glenn, our executive editor sitting back here. I met with Glenn, and of course I had researched up and made myself knowledgeable about some of the law here in Nevada, and I was talking to him, and he brought up the Public Records Act, and I was like, yeah, I mean, it's really great, the Public Records Act here. And after I picked his jaw up off the conference table because he couldn't believe I thought that the public records situation in Nevada was good, we started talking about it, and since then I've learned. And the problem here isn't so much the law itself, but just the willingness by governmental entities to flout it. And the problem is when that happens, I mean, the first step is I write letters and emails back and forth and back and forth and back and forth explaining how they got this thing wrong and how they better shape up and give us these records. And, I mean, sometimes we do get them, but oftentimes we don't. And when you don't, you're stuck in, best case scenario is you're going to be in court for a couple of years, spend a whole lot of money, and then you're going to get the records. And you can often get your money back, but even for an organization like ours that has a lot of resources, that's still a whole lot of money and a whole lot of time to be fronting for a few years. And of course, when it's the news, oftentimes 2 years later, it's not a story anymore. And when you're talking about the rest of citizens, I mean, there aren't a whole lot of people out there who have 2 years and hundreds of thousands of dollars to spend on Public Records Act, even if they have a pretty good chance of getting that money back in the end. And of course, when we do get the money back in the end, who's paying that money? It's not the lawyers we've been fighting. It's not the public officials who kept that information secret because they didn't want to be embarrassed. It's us. I mean, that's public money that's reimbursing us. And so the Public Records Act really is, for long term, probably the biggest challenge that we as a news organization and that news organizations generally in Nevada are facing, simply because too many governmental entities find that they're willing to fight the fight and spend the money even if they lose, and it costs the rest of us sometimes too much to fight, and even when we can, it delays it. We have had an interesting other side of the coin with access to the courts, where the law in Nevada for court access really isn't very good, or let me say wasn't very good, because this all changed a few weeks ago, historically, the law in Nevada really wasn't very good, which Ashley is saying to herself, how could that be? Court access is a constitutional right. Nevada can't take away your First Amendment right. But we have statutes in Nevada and court rules that are not consistent with the First Amendment. Interestingly, while governmental entities have flouted the Public Records Act and not lived up to the state statutes, in Nevada, the courts have mostly recognized that, without recognizing the First Amendment right, have nevertheless been reluctant to close courtrooms, even though the law often gave them, purported to give them the power to do it. We just had a case that the Supreme Court came out with here. It was actually a sister case to one the Review Journal filed, and it was filed by an organization called Our Nevada Judges. We had all briefed it and argued it where the Nevada Supreme Court has said, yes, this First Amendment right is there. You can't close courts willy-nilly. It was in the family courts where they're much quicker to close the courtroom. So we've actually sort of rectified that situation in the law, but interestingly, again, oddly, even though the law didn't purport to be on our side here, we'd never really had many issues with it.
Well, I promised to get some questions from you.
Thank you, good speakers. Now, I'm very naive about this case, but they seized all of these items from this reporter. Who was to protect all of that as all of this ensued? Was that locked in a black box and somebody had the key? Why couldn't they have gone in and started to look at stuff?
Sure. They recognized that we, let's say arguably at least, had a privilege in these devices, and they indicated to us that they would not look at the devices until there was either some sort of agreement on it or a court order that said they could go ahead and review them. And they gave us assurances they hadn't looked at them yet and they wouldn't look at them. A few months later, we found out that they had misrepresented that to us and they actually did look at the devices, because those are sitting somewhere at the police station. Since then, we've got court orders telling them they can't look at them, and they've said, okay, we're not looking at them. We, of course, do not know for sure how much they really have looked at them, what has happened. All we have is a court order and the threat to them of contempt of court and their word that they're not looking. But I mean, in the end, we can't physically stop them from doing it, and we remain concerned to this day that those are sitting there and that who knows in the future. I mean, if they haven't looked at them now, what's to say if those are still sitting in some evidence locker 2 years from now, somebody won't think to look at them.
And it was the phone. They conceded they looked at the phone, that there was a preliminary search of the phone, but then after that, they didn't do their full search of the phone. The homicide detectives haven't searched the phone. So that's what they've told us, right, but it's in a box and, someone has a key to it, someone there in the police department.
And that person isn't us.
Right.
If the professor will permit me, I've got 3 questions.
Oh, 3, okay.
First, my understanding is the case was decided by a 3-judge panel by an order rather than a published opinion. Would you discuss the significance of that, if I'm correct?
Yes.
Second, was Mr. Gehrman's estate represented in the action? The reporter's privilege is generally viewed by Nevada law to belong to the reporter. Had the estate asserted the same claims you made, it would not have been necessary to reach the decision about whether or not the organization possessed the privilege.
You are correct. It is an unpublished opinion, which, as Your Honor knows, it carries less precedential value, and won't be seen out there by people who look for it. I want to switch to the question about the family. The family did not intervene, did not take any position in this, and this might be a little, I don't want to get too legally technical. Our organization was not the only plaintiff in this action. Individuals who are reporters and employees of the news organization were also involved in this. Our argument was that the privilege belongs to them. It would be no different than, let's say, somebody delivered information for a reporter, but when they got to the office, they delivered it to the reporter's assistant. That's still the reporter's information that the reporter has gathered as part of the news gathering process. And just like that would be the reporter's, when the reporter gathers it, it also belongs to his editor. It belongs to the people up the line, and that those people could assert the privilege. The Supreme Court did not address that because they simply ruled that the organization could be the one to do it. What might have happened had if the family had gotten involved saying it was their devices. I mean, I don't want to speak for the police and the prosecutor what arguments they might have made. We made the arguments that the devices may not be ours, the physical devices, but the information on that devices very much is ours. We have an intellectual property right in it, for instance, the copyright and things that Jeff has written, and in the news gathering itself. And had we not brought the case at all, and had the family brought the case, I don't know that the police and prosecutors would not have argued the devices belong to you, but that information doesn't, and it would have been, a sort of mirrored argument. But, had the family joined us and we all did it together, maybe our arguments would have been stronger. I mean, they chose not to get involved in, we didn't ask them to. We certainly respect however they want to handle this tragedy, and in the end, they didn't get involved in one way or the other. He was asking, because it is an unpublished opinion by a panel of the court, could it end up being, are you asking whether there could be rehearing before the full court? Yeah, to circle back to just where we are in the case, it got sent back down for the special masters. At that point, the police and prosecutor said, oh, we don't need special masters. You, Review Journal, can just look at it yourself and then prepare a log of the items on the devices that you want to assert a privilege over. So after 15 months of litigation, they gave us more than we had offered at the start of the litigation, and a whole lot of money later, although at least it went to Ashley.
I wish it had gone just to Ashley, but.
So at this point, the review's going to take place, and we are going to assert privilege over some of the material on the phones. So it's certainly possible that the other parties will challenge our assertion of privilege, and that issue could go back up to the court. You might know better than I whether the court at that point, I guess certainly the court could at that point revisit all of, even the underlying issue. Given prior court pronouncements, pronouncements on these issues that weren't legally binding, but where the court expressed its opinion, I don't stay up nights concerned that we're going to lose this opinion in the future any more than I guess I do about anything that we win at the court. I think this case, as extreme as it was, representing such an extreme situation, made it clear that the importance of having the ruling the way that it came out with the court. So again, yeah, absolutely, it could be lost at some future time, but I think it's pretty settled, and I think the chances of something like this coming up again are rare, just given the utter bizarreness of the situation. But we'll see what if any fight we end up with over our assertions of privilege over specific items.
Well, the one issue that could come up again is if a reporter dies, whether it's under these horrible circumstances or natural causes, what becomes of the privileged information that reporter has? Mm-hmm. And unfortunately, I think that issue is still undecided even after this case. Would you agree?
No, I don't. I mean, I think, well, for presidential purposes, yes, given that this is an unpublished opinion.
So I have a question. How does the Fourth Amendment factor into this? So with illegal search and seizure, is that nullified in the event of a subpoena or a search warrant? And then second question is, can we as journalists protect our information more with passwords or encryption? And does that change their ability to look through our devices?
Well, on the second question, you can use passwords and encryption. I think most law enforcement agencies can figure out how to get into the device, notwithstanding your efforts to protect it. I mean, I think that's kind of like a constantly changing and evolving question. There are new technologies that are created, and then law enforcement figures out a way to get at them. And we wondered in this case, are we ever going to, we don't know Jeff's passwords. If we do get access to these devices, are we going to be able to see what's in there? Well, once we came to the agreement with them that they offered, well, why don't you guys just look at it? Hey, guess what? They had already unlocked whatever passwords were there. It was all there. So, so that's the answer to the second question.
Can I clarify?
Yeah.
I guess my question is, are there different legal ramifications if they encounter a phone that is encrypted versus unencrypted? Like an unencrypted phone, is it legally easier for them to look through? Or no? Okay.
The legal protection doesn't depend. I mean, we have had arguments thrown against our position in this case saying, oh, you say how important this information is and how confidential it is, but how come you didn't lock it up in encrypted lockboxes, But the practical answer to that is, reporters have to go about doing their jobs. You can make it super burdensome and then they wouldn't produce nearly as much news. So I don't think those arguments really would ever carry the day, personally, if that makes sense. On the Fourth Amendment question, so the Fourth Amendment, protects you against unreasonable searches and seizures. So you have to get a judge to sign a warrant that would allow you to go in and execute the search warrant, which happened here, unless, actually there was no search warrant here. This is where we're getting into weird criminal, procedural law, but there are exceptions to the search warrant requirement, and there probably, arguably was an exception here. You come across a person who is dead and you need to secure the evidence. And I'm not a criminal defense lawyer, but there probably is an exception that could be asserted in this particular case. Is that what you were wondering about?
Do you think that the erosion of, libel protections in part is based on the fact that the definition of journalist is no longer what it was, and that, to use a very simple term, just about anybody can go on the internet and call themselves a journalist? And do you think that that's that cycle or that repercussion that's coming from that, is that we're getting people that others don't respect in that way as a journalist, and so it's much easier then to just say, well, then I'm being libeled, or at least I'm going to file the lawsuit to see what will happen?
I see the increasing pressure I mean, Neil Gorsuch, in the opinions that he wrote, that he has written, I think there's maybe just been one, that he wrote, talked about this very thing. Now anybody can say anything because everybody has a microphone, everyone has access to the internet. So we shouldn't have these strong legal protections of the actual malice standard that I talked about in these modern circumstances. That was a doctrine that made more sense back when you had just a professional press putting out information, but we don't have that anymore. So that is a justification that at least Justice Gorsuch has put forward as a reason to undo the actual malice standard. I and people like me don't think that's a good justification. I mean, you can still be sued for libel no matter who you are. And we still have a professional press, right? We still have news organizations that do this all the time, and that is how they make their money. And we still get great information from the news organizations, largely in part, or at least partially in part, to the actual malice standard. Do you have any additional thoughts on that?
Yeah, I mean, I guess all predictions by me of human psychology wrong or your money back. I wouldn't be surprised if that is part of what animates things. I think the bigger factor is just the general negative swing towards the media in general. But I think at least maybe in small part, the media, of course, for years could argue that, and the professional media still can, we have layers of review over what we do. A reporter goes out and gathers the information, writes the story, an editor looks at it, there's fact-checking, there's challenge to it, there's a review process that results in, I think, better results. And the less of that there is, the less argument we defending these rights have to say, don't worry about it, because the journalism is getting it right most of the time, and when it doesn't, the law allows you to sue, and there's not too much protection. We need a lot of protection. And if people feel, rightly or wrongly, that there is so much misinformation out there that the people who need protection aren't the press, but rather the subjects of reporting, then there might be a more natural swing to protect those people rather than the press. I personally think it would be misguided. You're probably not all surprised that that's my opinion. And, in the end, I don't know if that's what's going on, but I certainly have concerns that it might be.
And if I may too, the other sort of side of this, while we're on the subject, is the challenge as far as actual malice goes. This is a standard that applies to public figures. And for a long time, it was the reason for that being that these are people with, power, social power, financial power, cultural power, to silence their critics. And it's, I think at least Gorsuch's opinion on this has said something along these lines. It's getting harder and harder to determine who's a public figure as well, right? The people that have social and cultural influence that, none of the three of us, have millions of followers on social media, people, buying the things that they say to buy and doing the things they say to do, that none of the three of us have ever heard of and wouldn't identify a picture of. And so, in that world where it's difficult to identify what a public figure is, that sort of weighs some challenges before a standard like actual malice that makes it very difficult for those kinds of people to sue. I don't know if that changes anything or not, but I think that's another part of the problem, I guess, if there is a problem with the Sullivan actual malice standard. I think we've got time for one last question. Not to put you on the spot as having the last question.
Yeah,
but
thank you.
Sorry.
I thank you for your elucid explanation of the problem. You brought up some things that I had not thought of. But my first question is, Jeff was killed. And has this person that we suppose killed him, has he gone to trial? Has he been found guilty or no?
No, his trial is set for currently
Okay.
set for March 18th.
Okay, so I guess I'm going back to the man was killed, and they're trying to find out who did it, and they found this one person. How are you going to feel if they don't have enough evidence and he's found not guilty? So I mean, I know there's a paradox there. And to not trust the police to do their job seems to me, I mean, I know that there are bad apples, okay, but you know, let's let them do their job and then take action. It just seems to me. But how would you feel if he gets off?
Well, I mean, if it really seems like he's guilty and he gets off, I won't feel good about it. But let me answer by way of an analogy. I'm an attorney, and we're attorneys, and there's an attorney-client privilege out there. And let's take a situation where this man was on trial, and let's say he had a cohort who helped him in the crime, who the police have not discovered. And the cohort came to me as a lawyer. I mean, couldn't come to me now in my job, but let's say I'm in private practice like I used to be, and came to me. I also wasn't a criminal defense attorney, but let's say he's not a very bright criminal, so he comes to me as a lawyer, and he says, hey, you know, will you represent me? And I say, sure, I'll represent you. He says, okay, well, I was part of that murder. I was one of the two people doing it. I need to talk to you because maybe the police are going to figure it out. Maybe the guy they arrested is going to tell them that I was one of them. But I was there. He did the stabbing. I drove the getaway car. Now, I as an attorney could not, ethically, and would not go to the police to say, hey, I have the other guy in my office, which would do two things. One, it would make sure we got the other guy who was part of this. And two, it would make sure we got the first guy, because now we have somebody who's willing, you know, who would testify and say, yeah, I was there, that first guy did the stabbing. Lawyers all the time keep information secret, and we all recognize that they can, that they do, and that frankly they should be able to keep that secret. And I don't see this as any different. In fact, I think one could argue this is more important than the attorney-client privilege. And you know, the state law treats it that way with the strength that it gives it, and the idea that there is privileged information that we should be able to keep secret, even though at times it might have, in individual cases, a negative impact. But in the grand scheme, it is far more important that we have the privilege and maintain that privilege than one particular individual situation. And in this case, I'm just very hopeful that the one time I'm involved in it, it doesn't go wrong.
And in that regard, I mean, I agree with what Ben said. And in fact, when you look at the legislative history of the SHIELD statute in Nevada, the legislators made clear that the reason why we have this protection is a little bit different than the reason why we have the privilege in other areas of the law, the one between attorney and clients, the one between priests and penitents, the one between spouses. Those are all legal privileges. The same thing would be applying here if, you know, you were asking somebody who was married to the criminal defendant, right? That person couldn't be forced to testify either, even if they knew, right? And the reason why we have this particular privilege is not just to protect a confidential relationship that's important in society for some reason, whether it be a marriage, a religious situation, or an attorney-client. It actually protects the entirety of the public. The freedom of the press, which is what the privilege protects, helps the public interest broadly writ, because only by protecting the confidential information that is provided to the press and these confidential sources can we have these stories that shed light on, government corruption, government wrongdoing, all of these things. And so just re-emphasizing what Ben is saying, I think the thought is that for the larger good of the order, right, we have this privilege that in a particular case may mean that a particular criminal defendant is not convicted even if they were guilty, for example. I also wanted to say, though, that in this particular case, the state has said from the very beginning that their case is extremely strong. I don't know how much of the evidence that you know about, but they have DNA evidence that the state says links this particular criminal defendant to the crime. They have videotape evidence. They have evidence that the way that the guy walks is similar to the way that the guy, you can see him on, Ring cameras from across the street. You can see the guy walking. They walk similarly. They found pieces of hat and shoes in a bag at the guy's house that matches the hat, the shoes, and the bag that the guy on the Ring camera is seen. The car is the same. So they are saying, hey, we have this super strong case. So, I'm not sure that whatever evidence is or is not on these devices is going to tip the scales in one direction or the other, unless you found some smoking gun. I'm coming over to kill you. If you have that voicemail on there, maybe then you would have a concern that you're talking about. But I don't know if that gives you any comfort that in this particular case, at least the state feels like they have the right person, regardless of what's on those devices.
Well, thanks very much, and please help me thank our guests. Yes, Warren?
I'd like to just say one thing, and thank you for your great work to support the Supreme Court.
Sure.
Thank you.